So I'm recording now. So we're just talking about the Sinnott case, and as I was explaining before I hit record, in some ways, Sinnott's decided in 1999 by the High Court, in 2001 by the Supreme Court, and it's kind of the culmination of a range of cases of this nature. The obvious one, I suppose, is Paul O'Donoghue's case, where children with their people on behalf of children with disabilities begin to use the courts really as a forum for pursuing their rights-based claims, where they had been, as it were, knocking on the door politically for years and not getting anywhere. And finally, they turned to the courts, hoping to get relief and support, and perhaps hoping to put pressure on the political system. And that culminates, as I say, in the Jamie Sinnott case. The facts of the Sinnott case are this is Kathy Sinnott, the mother of Jamie Sinnott, who takes the case along with Jamie against the Minister for Education. And you should read about the case itself. I can't remember in detail really the facts of the case in terms of what happened. I think, if I recall rightly, in the High Court, he won, Jamie Sinnott won, Justice Barr was the judge, and Jamie Sinnott won an award of damages. If I recall, it was a very substantial award of damages, possibly 300,000, I suppose, pounds it would have been at the time. I have that figure in my head. Again, I might be mistaken on some of the detail here, but won an award of damages for breach of constitutional rights. Now, I suppose the other key fact here was that Jamie Sinnott was 23, I think, by the time of the Supreme Court ruling. So I guess he's 21 by the time of the High Court ruling. In other words, he's over 18 by the time this family pursues this litigation in the courts. The question really in the case, in some ways, certainly as it was argued before the Supreme Court, was whether or not the right to free primary education. And remember, there is, as you know well at this stage, an explicit right to free primary education set out in Article 42(4) of the Constitution. And the question really is, and this, I suppose, is a question of constitutional interpretation, just of the plain words of the text of 42(4). Let me just have a little quick scan at 42(4) to see exactly precisely what the wording is. 42. 4, the state shall provide for free primary education. State shall provide for free primary education. So it doesn't, I wonder, did it refer to the child, but it doesn't refer explicitly to the child. So the question really was, who would benefit, or what categories of citizen, if you like, this obligation was owed to? And the state argued that that 42(4) envisages education of a scholastic nature. In other words, academic education, conventional, as it were, academic education. That's what the state argued. Now, as I say, Justice Barr in the High Court, you can have a quick scan at what he says there. Is he here? Yeah. He makes a finding in favor of the Sinnotts, in favor of Jamie Sinnott, making the point that really, and again, you can see the parallels with the cases in TD, like that, so much potential had been lost for Jamie Sinnott. That is to say that by the time he's 23, the benefits that could be gained from whatever the education was that he required, and it would have been, I guess, physical therapy of different kinds, enabling him to make better use of his bodily movements. I recall reading the case, finger movements and so on, maybe that he might have been able to, for example, feed himself. Now, again, as you can see, I'm sketchy quite on the detail of it, but whereas now, let's say that opportunity was lost, so the question was, well, had the state breached his constitutional rights? And the Justice Barr in the High Court said that it had, and made an award, as I say, of damages, a substantial award of damages. And again, like in the Paul O'Donoghue case 4 or 5 or 6 years previously, the judge found that the right to free primary education in 42(4) was a right that did not stop at the age of 12 or at the age of 18, but rather was something that depended on the citizen in question, and that the education that Jamie Sinnott needed very much would count as primary education, quote, primary in the sense of fundamental education, in the sense that what we were talking about was, let's say, educating him or assisting him to develop the skill of finger movement or whatever. Obviously not scholastic in nature, but primary, as far as the judge was concerned. Bear with while I admit somebody else here. And the state, I think, accepted, that there had been a breach of rights, did not contest the damages award in the Supreme Court. Again, as I recall, and I stress, in the textbook, Doyle and Hickey, you should read the account of the Sinnott case where you'll get more precise account of the facts, but rather appealed the question as to whether the right to free primary education in Article 42.4 was, extended beyond the age of 18, right? The state argued that it did not extend beyond the age of 18, and the state won in the Supreme Court. So you can see here's the High Court. The end result is that he has lost many years, which in all probability would have been of great value to him in the improvement of his physical and mental capacity, etc. That loss can never be fully restored, and so on. The ultimate financial decision makers and officials who devise budgets, etc., must have real awareness and appreciation of the constitutional obligations of the state to all the sectors of the community, and particularly to the rights of the grievously deprived, including those such as Jamie Sinnott, who suffer profound mental disability. Again, I won't read all through it again, but like, it is evident that the right to primary education would be fundamentally flawed if narrowly interpreted as ending at an arbitrary age, 18 years. Fine, Jamie Sinnott's history graphically underlines the importance of ongoing education and training from early childhood for as long as it is required. It follows, therefore, that in his case, there is a fundamental need for continuous education and training, fine, which is not age-related. Now, you kind of, sometimes you look back on these cases and you wonder, you'd like to know, why, you might say, why did the state appeal? In the sense that, like, the state's lawyers conceded the damages, like they didn't want to recover the 300,000, that had been awarded to Jamie Sinnott. Nor did they dispute but that Jamie Sinnott did have constitutional rights and that the state had been under an obligation to vindicate those rights and had obviously failed to do so, in the sense that it had conceded, that is to say, the state had conceded the damages claim. So why appeal? It seems so cold-hearted and pointless, you might say. Well, I don't know. I'm speculating here, really, in the sense that I haven't investigated the reasoning or the history of it. But like, basically, I suppose because it sets a precedent whereby, well, now, the state is on the hook, and the judges can, and individual litigants can go to the court in all kinds of other contexts, arguing that the state has a responsibility to vindicate this right to free primary education for people who are in their 20s and 30s and 40s and 50s and 60s, etc. Right? But also because, and I'm speculating, I stress, you ask yourself the question, if you look at the text of Article 42 of the Constitution, and we will be looking as a distinct topic at the question of constitutional interpretation later in the semester. That is to say, how do you go about interpreting ordinary words that are there in black and white in the text? Do you take a kind of a very literal interpretation, or do you take a harmonious interpretation, or whatever? In what contexts do you do one or the other, or some other approach, or whatever? But like, you might say, from a moral standpoint, if you're to just interpret the text in question in the light of the broader moral political vision of justice, you would say, well, certainly, the right ought to be understood in the way that Justice Barr understood it. But if you were to be legalistic about it, or if you were to be, let's say, formalistic or technical about it, or if you were to read it in the light of what provisions were immediately before and immediately after. Look where 42.4 is in the text of the Constitution. It's beside Article 40. It follows immediately from Article 41, which is the family provision. There's loads of other little subsections in there which talk about children and parents and the rights of parents with respect to educating their children, duties of parents, etc. In other words, clearly it envisages that kind of parent-child um, context, and therefore that the right to free primary education, whether it might involve scholastic education only or scholastic education along with other stuff, certainly it's something that seems to pertain to, let's say, the child, whether the child be under 12 or under 18, but certainly not into their 20s and 30s and 40s. And it was really on that point that the Supreme Court ruling hinged. And the Supreme Court judges decided the case in favor of the state on that question and ruled against the applicants. In other words, you might say, to put it crudely, that the bad guys won. Now, what's interesting, or at least the good guys lost. Now, kind of what's interesting is that Susan Denham, this was before she was appointed Supreme Court judge. Susan Denham, as you'll remember, she dissented in TD. In other words, putting it crudely again, putting it crudely, she was on the side of the good guys in TD, on the side of the vulnerable kids. Whereas in Sinnott, she was on the side of the state and against the vulnerable young person. And why is that? Well, I mean, I would suggest to you, like, that Susan Denham, is actually very careful and sober and measured and legalistic. And I mean that in a complimentary sense, in her reasoning, that there were legal constitutional arguments. Bear with, stop sharing. There were legal constitutional arguments in TD supporting the young applicants, right? And Susan Denham was persuaded by those arguments. Those in the majority were not. But equally, the legal, technical, or legal constitutional arguments in Sinnott, Denham just wasn't satisfied that they were sufficiently strong. She couldn't interpret 42.4 in the manner that the Sinnott wanted it interpreted. So let's have a quick look then again, sorry guys, at what the Supreme Court says in Sinnott. No, it ends at 18. Why? Mainly because Article 42 is located in the context of the family, and the meaning of the words child and children were clear in this context. But Adrian Hardiman, now remember, Hardiman, most of these judges, if not all, I think, were obviously on the same panel of judges who decide TD 5 months later. So Sinnott is decided in, like, say, April, May, and TD is decided in September, October of 2001. And Hardiman kind of, instead of just limiting the judgment to the question specifically of the right to free primary education and what it actually meant and when it stopped, he went on and elaborated more broadly about the separation of powers in Sinnott's case, and approved. You see that in the bottom left of the screen? He approves Costello's ruling from O'Reilly and Limerick Corporation, that distinction between commutative and distributive justice. He talks about the text of the Irish Constitution, what Article 17 says, and loads of other provisions in Article 28, I suppose, especially, indicating, as far as Hardiman is concerned, that when budgetary considerations are in play, or the financial matters, that the Constitution, the text of the Constitution, establishes and envisages that the political organs are responsible, not the judicial organ. And Hardiman goes on and talks about the separation of powers being a high constitutional value and so on. Okay, so that's Sinnott. You know what I might do? I'll stop share and I might stop recording there, and then put that as a stop recording, as a